Welcome to Caribbean Tea. From St. Vincent, Kendall Morgan, in Georgetown, Guyana, Dennis Chabral, and I am Vivian Williams in New York. High-profile indictment in the United States, allegations of gold smuggling and massive tax evasion, and at the heart of it all, a jurisdictional tug-of-war between Guyana, where the alleged fraud took place, and the United States, where the legal machinery is moving. This is Caribbean Tea, the podcast where we stir the pot on the region's most pressing issues: social, cultural, economic, legal, and political, with unflinching honesty and thoughtful analysis.
In October 2025, U.S. prosecutors unsealed a sweeping indictment against Nazar and Azruddin Mohamed, a powerful Guyanese father and son business duo. They're accused of defrauding the Guyanese state of millions in taxes and royalties through a sophisticated gold export scheme. But here's the twist. It's not Guyana that's bringing the charges. It's the United States, even though the alleged fraud was against the Guyanese government.
That raises a big question and a fascinating legal and political dilemma. Who should prosecute this case? The country where the fraud happened and the natural resources belong, or the country whose banking systems and shipping routes were allegedly used to move the gold and the money? It's a question that touches sovereignty, resource control, legal capacity, and geopolitical power.
For the Gavel to come down in a U.S. court, Guyana must extradite the Mohameds, barring some extraordinary rendition. That would mean deferring to the United States on a matter that goes to the core of Guyana's sovereignty. In this program, we will unpack the moving parts from the extractive sector and resource sovereignty to forum convenience, witness dynamics, extradition politics, and the capacity of Guyana's legal system. We'll explore why this case is more than a courtroom drama. It's a test of sovereignty and strategy in a new era of gold and oil wealth. This is Caribbean Tea. Let's begin.
All rise. Court is now in session.
Let's start by laying out what makes this case so extraordinary.
According to the U.S. indictment unsealed in October 2025, Nazar Mohamed and his son Azruddin Mohamed, two of Guyana's most prominent businessmen, allegedly orchestrated a multi-year gold smuggling and tax evasion scheme that spanned from 2017 to 2024.
The indictment speaks of a scheme spanning from 2017 to 2024, but it contains no allegation of specific conduct prior to October 2020. So, really, the indictment is based on conduct between October 2020 and June 2024.
The indictment paints a picture of a well-oiled export operation centered in Georgetown. Prosecutors allege that the Mohameds companies, including Mohameds Enterprise, declared a single legitimate shipment of gold to the Guyana Gold Board, paid the applicable royalties and export taxes, and then reused the same customs declarations and seals to move multiple additional consignments of gold out of Guyana, this time without paying any taxes or royalties. Much of that gold, according to U.S. authorities, found its way through Port Miami, concealed in shipping containers or commercial cargo. The indictment even cites an instance where approximately 5.3 million US dollars worth of gold was seized in Florida in connection with the scheme.
And the charges are sweeping. The indictment runs several counts deep, including wire fraud, mail fraud, conspiracy to defraud, and money laundering under US federal law. Each count carries serious penalties up to 20 years in prison per count, plus forfeiture of assets and restitution.
But here is the striking part: the alleged victim of this fraud is not the United States, it is the government of Guyana. The US isn't claiming that American taxpayers or agencies were directly defrauded. Instead, it's a certain jurisdiction because the money trail and trade logistics passed through US systems.
Vivian, why is that significant?
It makes this case, Kendall, uh, a first of its kind for Guyana and potentially precedent setting for the Caribbean and the United States. What you have here is a foreign government, Guyana, whose gold export regime was allegedly manipulated, but it is the United States, another country that's bringing the case, relying on its authority over international commerce, wire transfers, and the use of the dollar based banking system. This has never happened before. Extradition, yes, but not this factual scenario. So this is more than a gold smuggling or tax evasion case. It's a legal test of how far US law can reach beyond its borders when American infrastructure is used in a foreign fraud. That raises deep questions about sovereignty, jurisdiction, and who has the right to prosecute conduct that by every visible measure happened on Guyanese soil and a third country beyond the borders of the United States. One of the significant things about this here is that the case involves the extractive sector of Guyana. And the extractive sector, the natural resources of a country, is an important aspect of the sovereignty of a nation. So you have a case here where it is alleged that Guyana's sovereign resources are actually being defrauded by a citizen of Guyana, but it is not the government of Guyana that is bringing the charges here. It is the United States. It is as if you have a case here where the policing of the sovereign resource of Guyana or resources of Guyana is being outsourced to the United States. So, really, you could ask the question from the point of view of sovereignty: should Guyana be prosecuting this case or should it be the United States? And when we think of it in that way, is Guyana to some extent ceding some of its sovereignty, sovereign authority to the United States? And there is a second question in all of this: is the United States overstepping its sovereignty in trying to prosecute a case where the victim is another sovereign power and where the conduct that is being alleged is conduct outside of the United States? Here, what we have is allegations in the indictment that the infrastructure of the United States, that is to say, the financial sector of the United States, the banking sector, and the shipping or the ports of entry and exit of the United States, used not to sort of bring the goal into the United States for distribution or for fraud in the United States, but just simply as a transit point to Dubai. So, which is different from allegations where the goal is exported to the United States to be used and to be distributed in the United States. What the indictment is alleging is that Miami is used as sort of a transshipment transitory port from Guyana to Dubai, and from Dubai through Miami back to Guyana, and that what you have is electronic communication such as emails being sent from Guyana to two companies in the United States.
I was just trying now to figure out whether indeed the U.S. law has any extraterritorial aspect to it, as far as certain offenses are concerned, and also where do um, agreements or conventions or even bilateral memorandum of understanding or even tighter agreements on the matter of anti-money laundering and financing of terrorism come in. Could they possibly be applied here in this case?
Guyana's Vice President Barjatju has taken an interesting position on that issue. Let's listen to the Vice President and then come back and talk about it.
If you go to the United States, the laws of the US, and you Google it online, and you check mail and wire fraud, you will understand that what they did was mail and wire fraud. If you use through electronic communication in the United States, or even mail, and if it's interstate, it becomes federal. But anytime you use their infrastructure, which the Mohammeds use liberally, you can be charged, and you use it to defraud anyone, a person or an institution, whether that institution is a United States institution or a United States citizen, or an international institution, or a person who is a non-citizen of the United States of America, is the victim of the fraud living in another country, they can charge you for wire and mail fraud. So I've heard this stupid explanation of, oh, why would the US prosecutors indict him if the victim on these charges, when the main victim of the tax evasion is a Guyanese institution and Guyana? They need to check the law.
So let's talk jurisdiction. It is not as simple and as straightforward as Vice President Jatjo points out. The $1 million question really is, who should prosecute the Mohammeds? Unlike most transnational fraud cases, this one isn't about defrauding the United States or stealing from US taxpayers. It is about Guyana's natural resources, Guyana's royalty system, and Guyana's loss of revenue. And that's what makes this case so distinct from earlier rulings in the United States that permitted the use of US extraterritorial jurisdictions. And in a moment, Dennis, I will look at the precedent map or history, looking at two cases that really have dealt with this matter, and compare them with the Mohammed's case. So, Dennis, let's look at where the law in the United States stands now with respect to extraterritorial jurisdiction. That is where the United States extends its criminal law to persons and conduct outside of the United States. There are two significant cases that we must consider. It started in 2005 in the case of Pasquantino versus the United States. Fast forward to 2021, we have the case of the United States versus Ojedukun. The Pasquantino case involved two brothers, Carl and David Pasquantino. Then came 2021, Sian Banjo Ojedukun, a Nigerian. These two cases help us to understand where the United States stands with respect to extending its criminal law extraterritorially to target persons and conduct outside of the United States. So what we see in Pasquantino, they're in the United States and they're involved in conduct within the United States, using means within the United States while they are within the United States. Now let's look at the Ojedukun case. Different case, involved a Nigerian. In this case here, we could see Ojedukun in Nigeria. You have co-conspirators in the United States, and they're using the banking system and also other means within the United States. Accuser outside of the United States, effects in the United States, and victim in the United States. Now let's look at the Mohameds case. The Mohameds case is different. In the case of Mohameds, what you have is an alleged defendant, or you could say an accused, operating outside of the United States. And you have a victim, which is a foreign sovereign, the government of Guyana, outside of the United States. And the only basis upon which the United States is extending or having a claim to extraterritorial jurisdiction is on the basis that the gold on its way to Dubai made a stop in Miami. And logistics companies, therefore, in the United States facilitated a transshipment or a transitory route that involved a stop at Miami on the way to Dubai. And that there was electronic communications, emails sent from outside of the United States to a company in the United States. Now, the facts in this case, therefore, raises questions as to whether there is a significant nexus between what is alleged in the indictment. And there could always be a superseding indictment where additional facts are alleged. But we are looking at what is alleged in the indictment as it stands. So the indictment as it stands basically only connect the United States because of emails sent to an email address for logistics companies within the United States. A brief transit stop of the goal in Miami on its way to Dubai. While you could have a superseding indictment and further evidence could actually come up at trial, the way federal indictments work, they're very detailed because there are standards of pleadings when it comes to federal indictment. We also should consider the fact that the Mohammeds were sanctioned more than a year ago. So if you're talking about financial transactions or any sort of shipment activities, the United States government would have had significant amount of time to have all of the details in the indictment. So we don't see those details. What we see is what could be considered tenuous connections between the conduct alleged and the United States, and so it raises questions whether, under the circumstances, that the United States would exercise extraterritorial jurisdiction in this case.
So, Vivian, against that background, given what you've described as, limited nexus between what the Mohammeds are accused of, and what did take place in the U.S. jurisdiction. If the matter is prosecuted in the U.S., um, can this be seen as outsourcing justice over the extractive sector in Guyana to the U.S.?
Uh, Kendall, that's actually a very important point that is being raised here. Before I answer the question, I'm trying to get up this comparison. So here we're looking at the two cases and what you see with the blue and the yellow. The blue demonstrate the domestic conduct that has a nexus with the United States in these three different cases, and the yellow is an illustration of the extent of foreign conduct that is alleged in the indictment. You could see in Pasquantino, the 2005 case that involved the Canadian government, there is a high level of domestic conduct creating strong nexus between the United States and the criminal conduct alleged. In Oshidukun, you also have significant domestic conduct that created a nexus between the United States and the criminal conduct alleged. When you look at the Mohammed case, on the other hand, the indictment, it is the nominal level of domestic conduct that connects the United States to what is alleged in the indictment. And here we're focusing on what is in the indictment, not what is said outside of the indictment. You take what is alleged in the indictment, and this is what we have in terms of an illustration of the nexus of the United States to what is taking place here. Now let's address the question you raised, Kendall, with respect to the outsourcing of sovereignty. There are a couple of things that are important here. One is that let's examine the conduct really that creates a nexus with the United States from which criminal jurisdiction is sought. You're talking about electronic communications, emails, and we'll look at what Vice President Jack Deal said. If the United States is able to extend criminal jurisdiction simply because of an email sent in a scheme where one person defrauds another, the person that is defraud that the accused is acting outside of the United States and the victim is outside of the United States. But all that you have is an email communication that lands on a server in the United States. What does it mean? If you extend jurisdiction in this way, what will happen is that any corrupt scheme, any sort of fraud that that occurs between, let's say, Demerara and Borbis, that involves an email or that passes through an email that lands on a server in the United States, the U.S. would then have wire fraud uh, jurisdiction or extraterritorial jurisdiction to charge that person. If we then consider merely speaking about the use of any proceeds or any funds that involve uh, a fraud or a corruption where the actual fraud is outside of the United States and the victim is outside of the United States, it would mean that if you have fraudulent conduct at the central housing and planning, for instance, the act occurred outside of the United States, but someone then take some of the proceeds from that corrupt transaction and purchase a property in the United States will then have jurisdiction simply because there was, in fact, some of the proceeds entered the United States, even though the means by which the proceed entered the United States was a lawful means. But in the case here, it is even more significant. The money is not just, and the gold is not just landing in the United States. It is, the United States is just used as a transit point. And the federal statute on extraterritorial jurisdiction specifically speaks to this in a manner that simply says that extraterritorial jurisdiction, there's a presumption against extraterritorial jurisdiction. What you have to prove is a significant nexus that has effect in the United States. The two cases that we looked at are cases where you had effect by using the system in the United States to defraud another sovereign, and where you actually have someone operating outside of the United States but creating victims within the United States. That's not what is alleged in the case of the Mohammeds. And so the question then becomes, as you asked, isn't this really outsourcing jurisdiction, the US or Guyana outsourcing jurisdiction to the United States? And that really would be a question that I think is of interest for the Guyanese authorities to consider. If it is true that its sovereign resources are actually being defrauded by its citizens or anyone, shouldn't Guyana step forward and play a lead role in prosecuting the crime, particularly when the acts are taking place within Guyana and where the victims are in Guyana?
So when you strip all this down, it's not just about the Mohammeds or their companies. Sovereignty is a big part of it.
Well, sovereignty plays a major part because, on one hand, extraterritorial criminal jurisdiction is US extending its sovereignty beyond its borders, which is why the statute simply requires that there must be a significant nexus. There is a significant nexus test before the US sovereignty could exercise jurisdiction. So the United States is a sovereign authority that has only powers within its own territories. So you can't exercise sovereign authority beyond your sovereign jurisdiction. And so the statute, even though it says that there could be extraterritorial prosecution for conduct, you have to create a nexus, a significant nexus with a country. And that occurs where you are producing effects within the United States. When we look at the indictment for the Mohammeds, we don't see, or it is not alleging, that the United States is a victim. Yet you have the United States seeking forfeiture, forfeiture of the proceeds and forfeiture of the uh, natural resources of another country. And if you don't have significant nexus, the question is whether the US is overreaching its jurisdiction. And that would be a question for a US court to determine whether the statute is being overextended. And then there is the other aspect, whether Guyana is ceding sovereignty by allowing another country to take up and play a lead role in prosecuting. Countries really do not give up participation in prosecuting, policing their sovereign resources.
So,
And that's what we're seeing here in this case.
Where does this leave the chances of extradition to the United States? If the United States wants to prosecute these gentlemen, obviously they will need them to appear before a court in the U.S. Do you think at all that the U.S. stands a good chance of having them be removed from the jurisdiction of Guyana?
Well, Dennis, the process of extradition is a multi-layered, very complex process. And at this point in time, I want to take a look at what that process looks like. So let's look at what the process entails, and then we talk about what really are the prospects. Step number one, U.S. indictment and warrant. It all begins in the United States, where a federal grand jury issues an indictment. That's a formal criminal charge, and a judge signs a warrant for the arrest of the defendants. That's the stage we're at this point. Step number two, jurisdictional challenge. At this stage, the defense counsel in the United States can step in to argue that the alleged conduct falls outside U.S. jurisdiction. They may say, for instance, these are acts that occurred in Guyana, not the United States. This is called a jurisdictional challenge, and it tests whether the indictment shows a sufficient extraterritorial nexus, meaning a clear connection to the United States territory. If that connection is weak, a U.S. judge could even dismiss or stay the case before extradition begins. Step number three. If the indictment survives, it moves to the U.S. Department of Justice's Office of International Affairs. That office reviews the case to make sure two things are met. One, the treaty with Guyana applies to the offenses charged. And two, the principle of dual criminality is satisfied, meaning the conduct must also be a crime under Guyanese law. Only after that internal review does the U.S. formally prepare the extradition request. And that takes us to step number four, transmission of the extradition request. Once cleared, the request is transmitted through diplomatic channels to Guyana's Attorney General, not directly to the courts. The document includes the indictment, arrest warrant, and supporting evidence. And then we move to step number five. Now the process moves to Georgetown. The Guyana court examines whether the U.S. request complies with the 1933 U.S.-UK treaty that governs extradition between the two countries, and whether the alleged offenses are extraditable. At this point, the defense in Guyana can again intervene, challenging both the sufficiency of the evidence and whether the treaty even covers the alleged crimes, especially if they argue these are tax or royalty offenses that don't appear on the treaty's enumerated list. Then, step number six, the final stage. Finally, once the court rules that extradition is legally permissible, the decision passes to the executive, Guyana's Attorney General or President. They decide whether to actually surrender the accused to the United States. That's a political and diplomatic judgment, balancing law, sovereignty, and foreign relations. Here is where the political temperature in the country, the political landscape, will play a significant role in whether the executive finally decides to extradite the defendants from Georgetown to Miami. Dennis, I would be happy to address your question here now. So step number two is where the parties have not made any moves. So here's where you could look for what moves the different parties will make. Where we are is stage number one. We just have an indictment. The Mohammed's legal team, even with him not present in the United States, they could have lawyers approach the court in the United States and raise the arguments that I have pointed out, that the various allegations in the indictment do not satisfy a sufficiently strong nexus with the United States for extraterritorial jurisdiction to be applied. They will, and here's where I think Vice President Jagdew failed to look at where the United States law stands at this point in time. There has never been a case in the United States where extraterritorial jurisdiction was applied to the facts as present in the Mohammed's case. We have had extraterritorial jurisdiction where someone stays in the United States and commit criminal act using systems within the United States to harm others outside of the United States. We have had a few cases where someone stays outside of the United States and use the systems within the United States or other means to create harm within the United States. Extraterritorial jurisdiction was upheld in those circumstances. What we have in the fact pattern in the indictment as presented to the courts in the Mohammed's case are these: a foreign accused sitting outside of the United States, allegedly engaging in fraudulent conduct involving the sovereign resource of another sovereign power or government, creating harm not within the United States, but outside of the United States. The only nexus we have is electronic mail and the use of the banking system. And as I pointed out earlier, there is a presumption against extraterritorial application of the United States law. So the government will have to prove that the sufficient or significant nexus test is satisfied. So that's one thing that you could find happening at step number 2, even before the Mohammeds are extradited to the United States or any request is sent. Their lawyers could approach the court and say, this indictment must be dismissed because what is alleged are not events or conduct for which the United States jurisdiction could extend. In any case where a person is appearing before a United States court, someone outside of the United States, it has to be shown that person is entitled to what is called constitutional due process. And as part of the constitutional due process, it has to be established that when the person engaged in the conduct complained of, that person should have had an expectation that he or she would be subject to United States jurisdiction. And courts have repeatedly, particularly in the civil realm, held that mere passing of funds through a US bank account is not sufficient to establish that significant nexus in the United States. And the courts have also held that the mere use of electronic mail does not meet the test of significant connection with the United States for due process and jurisdiction to extend. And here is where I think that there is a significant gray area. One, it will create a precedent in the Caribbean, because what it will mean that if the United States is able to extend the extent to which extraterritorial jurisdiction is applied, that businesses operating not only in Guyana, but throughout the Caribbean region must begin to have a different level of risk and compliance assessment, because every email you send and every bank transaction that you engage in could then subject you to the criminal jurisdiction of the United States. And we have to recognize that this case stretches the extension of United States extraterritorial jurisdiction in a manner not seen before. And again, I'd like to just put this up again for us to have a perspective. This is the first case where the Supreme Court first said, right, in the Pasquantino case in 2005, that U.S. extraterritorial jurisdiction could apply. But this is, when you look at the level of domestic nexus, you could see it almost cover the entire block. and then you look at the other case, its significant involvement or significant nexus of the conduct alleged in the United States. And then when you look at the Mohammed's case, it's just a slight nexus with the United States. And so that's a lively legal issue as to whether the United States will find that there is significant nexus for the indictment to stand. So to answer your questions directly, Dennis, what I'm saying is that you could see a possible challenge by the Mohammeds even before the extradition request is generated and sent, challenging U.S. jurisdiction, having their lawyers appear and challenging U.S. jurisdiction way up to the appeal chain in the United States. If such a challenge is mounted, what happens is that the extradition request or the entire proceedings could be stayed until that question of U.S. jurisdiction is fully determined.
I don't know if before you jump ahead, Vivian, if we could touch a bit more on the whole issue of the reach and the implications for Guyana and the rest of the Caribbean, because it you can't help but look at the fact that we are so heavily dependent on the U.S. financial system for business transactions. And the whole issue of using U.S. banks for correspondent banking, for clearing of transactions, that wouldn't you consider it to be a cause for worry for businesses that may actually, for the most part, be handling very legal transactions, but may find themselves slipping up from time to time, that they may have cause to worry about this reach that the U.S. may have?
You are hitting it the nail on the head, Kendall. If U.S. extraterritorial criminal jurisdiction is extended in this way, given the extent, the magnitude of the U.S. financial system, given the extent to which electronic communication is exchanged, what you have is a situation where the United States reach is will touch almost any transaction, almost any conduct becomes reachable by the United States, the long arm of the United States criminally. And so the issue of whether the United States has jurisdiction is a bigger issue than Vice President Barjactu has actually considered. And I think that he has not considered the fact that what you have is sort of outsourcing, standing back and have another sovereign power police your sovereign resources, and that you're also looking at nominal conduct, that if criminal jurisdiction of the United States is extended to that extent, that you really have serious issues.
Vivian, I have one question here. I think I need to stitch in here. Is what if the United States Supreme Court ultimately rules in favor of the United States, and so Mr. Mohammed and his father will have to come to Guyana according to that decision?
Even come
But
to the US.
the Mohammeds decide to challenge the issue of jurisdiction in the Guyana courts, and should they win here, which one will have precedence in determining whether they should go or stay?
Dennis, you have asked a very, very important question. You see, when we talk about the political temperature and the political landscape and its impact on whether the executive ultimately decides that it will extradite, these are issues that the executive will have to consider. The United States could litigate and adjudicate the question as to the breadth of the United States criminal law jurisdiction. How far in the world could the United States criminal law reach, and what circumstance? An independent sovereign state like Guyana must have to then also consider to what extent it allows the laws of another sovereign state to penetrate its own territory, and to what sovereign effect. It's different when we talk about multilateral cooperation, where you have a crime in one other sovereign state, and they're asking you for assistance in order to address that and to adjudicate that matter. It's different when another sovereign is extending its reach and particularly addressing matters pertaining to your sovereign resource. And I want to now, Dennis, add to the questions you raised, you and Kendall, to hear from Senior Counsel
But
Timothy Jonas
but
and what
but,
is
but,
his
doc- but
perspective.
Dr. Williams, you haven't answered the question.
What aspect of it I haven't answered?
Where should on the question of whether whether Guyana should accede to the U.S. ruling, or should it accede to the local ruling with respect to whether the Mohammeds should go to the United States based on the whole question of application of extraterritoriality of the U.S. law,
I think
and
I
who
asked.
has jurisdiction over these offenses. Is it that the Guyanese court has jurisdiction of these offenses and the Mohammeds should face trial here, or it is that the U.S. has jurisdiction over these offenses and they should be tried in the United States?
I think I answered that question. I'll come back and answer it. I want you to listen to Senior Counsel Timothy Jonas and what he said on this, and I will tie my response also at the back end.
To me, the real tragedy, the real shame that no one's looking at is that in those indictments and those charges, the offense is that Guyana has been deprived of tax revenue from the export of this gold. So the loss is tax fraud in Guyana. Whether it's proved or not my problem, not my business. The only way the US claims jurisdiction, claims even to have any interest in this, is because it says some of the money in the purchase of this gold passed through a US bank. What on earth is the matter with our government and our systems and our prosecutorial system and our revenue system and our customs agents, that as a matter of record keeping, we can't identify, investigate, and prosecute the kind of charge which obviously is taking place in Guyana, and if true, is hurting Guyana, but that got to be done in the States. So what we are admitting then is we are a failed state. And what's interesting is I see PPP loyalists who are in the know because they announce it on Facebook before it happens. They're saying, wait, something large is coming. The Mohammeds are in trouble, wait and see. So they know, they're in the know. And they're not recognizing that when they crow, because they heard a whisper about US acting, they're acknowledging the failure of their own systems because they can't prosecute and enforce their own rules and their own laws. We have to fix our systems, and I think for me that's where the problem is.
Dennis, I think that Senior Counsel Jonas touched on the issue in the way that I would touch on it and would respond to your question. That's a matter that as a society, Guyana really has to consider, and our judicial system will have to think about its independence. The United States courts will say, here is how far we think our laws could go. The Guyana court, the judicial process will then have to say, but wait a minute, how far could another country's law reach? And if, in fact, this is a crime against this country, should our laws and our judicial system and our courts actually be used in order to address the allegations against the Mohammeds? And that is why I put this as a test of our sovereignty, whether Guyana is a sovereign state. Mr. Jonas talks about a failed state, whether Guyana as a sovereign state has is stepping forward to say that it will act like a sovereign and a strong sovereign. And if Guyana cedes sovereignty in the region and the US extends its sovereign authority in the region in this way, then what are the likely outcome that you could see? I could also point out here, Dennis, another important aspect that is going to play out. When you look at the treaty upon which extradition is based between the United States and Guyana, that it only permits extradition of enumerated sets of criminal offenses. And one would have to read those enumerated list of offenses or crimes to see whether a crime against the sovereign state Guyana is a crime for which extradition to another sovereign is possible. I could also say to you that these considerations are contained in the body of that treaty because the treaty addresses the question if there is a pending criminal proceeding on the same matter that it has to be finished, where you have two states exercising jurisdiction simultaneously, what you have multi-state jurisdiction, that the state, Guyana, must first exercise jurisdiction, primary jurisdiction, before it cedes and allow a second state to exercise jurisdiction. And here's where we have another interesting twist in the Mohamed's case. The indictment in Miami includes the Lamborghini. The Lamborghini is a matter for which there is pending criminal proceedings in Guyana over. What will happen is this. The courts of Guyana will have to determine whether the executive could take the Mr. Mohamed, pluck him out of the judicial process to answer charges on the same matter for which charges are pending against him? Or would we see the government of Guyana withdrawing the pending Lamborghini charges against the Mohammeds? And then we come to a second issue with respect to this case. Which is the convenient forum? Which is the forum that could best determine and sort of lead a criminal prosecution in this case? When you look at what the indictment alleges, the United States cannot and is not likely to be able to convict the Mohammeds without witnesses from Guyana. And I'll pick up on this after we listen to former chairman of the Gold Board as he explains what is the process that gold exportation involves.
Now, let me tell you how this process works. What's the process? What's the procedure for export, legitimate export of gold? It's got four sets of eyes there. It's got the exporter, whether it's an ounce of gold or 1,000 ounces of gold, prepares his documents, his or her documents. It's got to be a licensed exporter, by the way, and says, we are preparing for this flight and we've got this cargo and we need for it to be processed. Four sets of eyes have to be there, four state agencies: the Guyana Gold Board, the Guyana Revenue Authority customs officials, the Guyana Police Narcotics, and CANU. Four of them. They all have to be there to inspect this cargo of gold, to weigh it, to seal it.
Yes, Dennis. So what you heard from the former chairman of the Gold Board is a complex multi-agency process for the exportation of natural resources in Guyana, gold. So imagine a jury in Florida where the allegation is the Mohammeds in Guyana engaged in fraudulent conduct, smuggled gold out of Guyana. Where are you getting the witnesses to explain that process and to explain to the jury how it is the Mohammeds were able to evade that process, and whether in fact the gold was in fact exported with the authority and the consent of the various agencies of Guyana.
Isn't there scope for mutual legal assistance in this regard?
While in this case, what you will have, and that is what you call, which is the convenient forum. Guyana could prosecute if you talk about the multilateral cooperation. The United States has the machinery, the documentary evidence, it would seem, and Guyana could lead the prosecution where Guyana has the witnesses, the people who could testify and must testify in order for the fraud to be established. If Guyana decides to prosecute, it could use the same bilateral cooperation agreement it has with the United States to obtain the documentary evidence that the United States has, to tie that with the testimony of the witnesses in Guyana. Because for the United States to prosecute, it would have to rely on Guyana shipping those witnesses to Miami to testify as to how this happened. I don't know if the nation has recognized that what will happen if the case goes to a court in Miami. The government of Guyana will be on trial. Guyana's administration of its natural resources would be on trial. That is what the defense is going to put on. And a jury is not likely to convict without being able to examine what really is this process and the systemic failure, and whether there is corruption in it, whether there is explicit or tacit approval by the state in the conduct alleged against the Mohammeds. You could expect that there would be a trial of the Guyana government on this question in Miami if the case gets that far. And when we consider the convenience of the forum, here is again Vice President Barjak.
So let me say this here now, that the GRA, the police, must immediately start the investigation of all of those corrupt officials who collaborated, and the gold board, who collaborated with the Mohammeds in smuggling the gold in every period, in the APNU period as well as the period under the PVP.
How do you say to a jury in Miami that someone defrauded a government and the person is not even indicted by the government? The person is not even charged by the government. That the government that is defrauded is now talking about doing its investigation. So how do you convince a jury in Miami to convict someone when the victim has not even instituted charges? And as I pointed out earlier, Dennis, if the government of Guyana institute charges against the Mohammeds, as the vice president is indicating that he is instructed an investigation, how do you then cede a sovereign criminal jurisdictional authority to another state while you are still sorting things out at home? These are important issues and important layers that I think that this case present. And when you look at what the vice president is basically saying, that what if that investigation, as so many other investigations in Guyana, turn up to find no corruption, turn up to find that there was in fact approval, officials of the state and state agencies were in fact authorizing the movement of natural resources of the country out of the country. what happens with respect to that? And how do you stand as a prosecutor in Miami, a U.S. attorney in Miami, and say to a jury, send these people to 20 times 11 years in jail the rest of their lives for defrauding someone else when the someone else couldn't even come forward to show that he or she was defrauded? This is the complexity and the unusualness of the Mohamed's case, and it's the reason why I started out by saying it is a one of its kind, that there's never ever been an extradition request of this kind, and that the jurisdictional sovereignty of Guyana was never tested in this manner before, and the jurisdictional reach of the United States was never before tested with the facts as alleged in the indictment against the Mohammed. And I'm speaking to the indictment that currently exists. There might be other claims, there might be other, but they are not part of the indictment. And the Mohammed's team is likely to move against the indictment as pled and as presented to the grand jury in the United States. So it's not as simple as Vice President Barjacdio says, that if you sit in South Georgetown and you send an email for that passes through a server in the United States that cause harm to somebody in Eccles, that the United States could block you and simply say it has jurisdiction. It does not work like that. Criminal laws don't exist beyond the borders of a sovereign state. So the sovereign state has to be able to show some impact on the state itself. The email in and of itself, someone sending an email to Miami saying, could you ship X from Miami to Dubai? That's not an email that constitutes a crime. And what we must also recognize here is that the United States has not indicted the logistic company or anyone from those companies as being part of the conspiracy. So what that seems to suggest, that there is no evidence that when the request or the email was sent requesting that these companies ship the items to Dubai or from Miami back to Guyana, that they didn't have the mental element to constitute this sort of conspiracy that is being spoken about. So there are lots of parts here. If the United States had said, look, there was part of the conspiracy in Guyana and there was part of the conspiracy in Miami, and therefore we have the co-conspirators in Miami that are co-defendants, that is a different thing. No criminal conduct has been alleged against the persons in the United States. And I think that this is the case is much more than is being spoken of. When we examine the U.S. indictment against the Mohammeds, one of the most pressing legal questions is not about guilt or innocence. It is about jurisdiction. Can the United States prosecute conduct that allegedly defrauded the government of another sovereign nation, in this case, Guyana? To understand the stakes, it helps to revisit one of the most pivotal U.S. Supreme Court decisions to ever test those boundaries. Pasquantino versus United States in 2005, the case we have been talking about earlier. In that case, 3 Americans were charged under the federal wire fraud statute for smuggling liquor into Canada and avoiding Canadian taxes. The US government prosecuted them, arguing that the scheme used interstate wires, phone calls, and electronic communications within the United States. But a deeper issue was whether US prosecutors were in effect enforcing Canada's revenue laws. The Supreme Court of the United States, in a narrow 5-4 decision, that is, 5 of the justices ruling for and 4 against, a deeply divided court said, yes, the US could prosecute. The majority, led by Justice Clarence Thomas, reasoned that Canada's lost tax revenue was property within the meaning of the federal fraud statute, and that using US wires to further that scheme was enough to make it a domestic crime. But a decision tore the court apart. Justice Ruth Bader Ginsburg penned a powerful dissent that warned the majority's reasoning broke with centuries of international restraint. She reminded the court that the revenue rule, a principle of comity dating back to 18th century English common law, prohibited courts from enforcing or punishing violations of another sovereign's tax or revenue laws. Justice Ginsburg wrote that by prosecuting the Pasquantinos, the United States had crossed a dangerous line. She warned, and I quote, by allowing this prosecution, the court permits our government to punish conduct that implicates another sovereign's right to determine its own revenue laws, a step the common law revenue rule was designed to avoid. So there is a common law revenue rule that prevents one sovereign from adjudicating matters pertaining to the revenue, the sovereign revenue of another sovereign state. And Justice Ginsburg didn't stop there. She stressed that the wire fraud statute was never meant to police frauds against foreign governments, and that this kind of expansion invites conflict rather than comity among nations. What makes this decision even more remarkable was that the court's division wasn't ideological. It cut across traditional political lines. Conservative justices at the time, like Scalia, joined the dissent, united by a shared conviction that courts must respect the boundaries of national sovereignty. It was a rare instance where judicial philosophy trumped identity. Now, 2 decades later, the court looks very different. The justices that decided the Pasquantino case are no longer on the bench, except for Justice Thomas. And no one can say with certainty now how a similar case or the same Pasquantino case would be decided if it goes before the court today, a differently constituted court. But even then, Pasquantino was a warning that expanding American criminal jurisdiction into the affairs of another sovereign could erode the very foundation of international legal order. We're in that territory again with the Mohameds case. Really, that's what makes the Mohameds case even more extraordinary. Unlike Pasquantino, the alleged wrongdoing here didn't begin in the United States. It didn't involve conduct and co-conspirators operating within the United States. It began in Guyana, involving Guyanese gold, Guyanese custom declarations, and alleged losses to the Guyanese treasury. The only US connection is that the gold passed through Miami and that US banks may have been used for transactions. Justice Ginsburg's dissent closes with words that ring even louder today, especially as we look at the Mohameds case. She says, and I quote, today's novel decision is all the more troubling for its failure to take account of Canada's primary interest in the matter at stake. United States citizens who have committed criminal violations of Canadian tax law can be extradited to stand trial in Canada. Canadian courts are best positioned to decide whether and to what extent the defendants have defrauded the governments of Canada and Ontario out of tax revenues owed pursuant to their own sovereign excise laws. Replace Canada with Guyana, and her warning could not be more relevant to the Mohameds case and what we have been talking about. Precisely what Justice Ginsburg addressed there is what Senior Counsel Timothy Jonas pointed to in the earlier clip that we played. In the Mohammed's case, what we are talking about, not extraditing Americans from America to stand trial in Guyana, as Justice Ginsburg says, even if the culprits are in the United States when they defraud a foreign government, that they should be extradited to stand trial by that foreign government in that foreign country. The Mohammed's case has a different twist. It is where the accused are in the country that they're accused of defrauding, and the question that will be before the court is whether they should be extradited from the country whose sovereign resource and sovereign revenue has been defrauded to a second country for that second country to engage in the prosecution. So let's take a moment and let's go back and listen to what the major players in Guyana are saying with respect to this issue.
If you use through electronic communication in the United States or even mail, and if it's interstate, it becomes federal. But anytime you use their infrastructure, which the Mohammeds use liberally, you can be charged, and you use it to defraud anyone, a person or an institution, whether that institution is a United States institution or a United States citizen, or an international institution, or a person from who is a non-citizen of the United States of America, is the victim of the fraud living in another country, they can charge you for wire and mail fraud.
What on earth is the matter with our government and our systems and our prosecutorial system and our revenue system and our customs agents that, as a matter of record keeping, we can't identify, investigate, and prosecute the kind of charge which obviously is taking place in Guyana, and if true, is hurting Guyana. But that got to be done in the States. So what we are admitting then is we are a failed state.
All eyes would clearly be on what happens to the Win party, either way, and how visible the ruling PPP seeks to be in the court process, or at least around the court process. But I guess the question that the viewers to the program would want to have answered, as we've attempted to do in the past, is what are the implications for the leadership of the WIN, and also about its own sustainability if the Mohammeds have to end up in the US to answer to this indictment?
Well, I think there is, as we discussed in our last episode. So if anyone is viewing this episode and didn't look at the previous episode, please go back and look at Caribbean Tea for the previous episode, where we talked a lot about the political consequences and the scenarios that WIN faces. But I think there's also political exposure for the ruling party. There is political exposure because, depending upon the political uh, climate in the country, as the case unfolds, questions could begin to uh, pop up as to why is it the government of Guyana is ceding jurisdiction to the United States for the prosecution of allegations that the government of Guyana is being defrauded of no less than significant quantities of its natural resources. I think there could be political fallout in terms of, if the case exposes negligence or corruption in the handling of the natural resources of the country, that you could have political fallout for the ruling party, because you could have in a trial an exposure that shows that the government has really been reckless in dealing with the natural resources of the country. You could also have political exposure for the ruling party if there is public sentiment that the government, without any sort of pushback, allowed America or allows America to push its extraterritorial jurisdiction too far into the country. Because I think at some point in time, people will sit back, the money class in Guyana will sit back and say, am I facing criminal exposure for these very things that I do? Am I facing criminal exposure for the emails, electronic mails that I send, WhatsApp messages that I may send that land within the jurisdiction of the United States? And every financial transaction that I do that is somehow routed through the United States, regardless whether it pertains to a transaction in the United States itself, exposes me to the long arm of the criminal law or criminal justice of the United States. I think those things could create political exposure for the ruling party as this case unfolds. At the end of the day, this case isn't just about one indictment or one businessman. It is about something much larger: the delicate balance between sovereignty and enforcement, between a nation's right to govern its own affairs and the global reach of another's legal system. If the United States succeeds in prosecuting a case that centers on Guyana's gold, its taxes, its royalties, its internal administrative acts, it risks setting a precedent that quietly transfers jurisdictional power from the local courts and executive institutions of smaller states to the far-reaching machinery of a foreign system. That's why the role of Guyana's Attorney General, the local judiciary, and the executive branch cannot be overstated. Their actions will determine whether Guyana cedes that jurisdictional ground or defends it as a matter of constitutional and sovereign right. The Mohameds case has become more than a prosecution. It's a test of principle. It will reveal how small nations navigate the intersection of global power and domestic authority, and whether sovereignty still has meaning in an era where borders are porous but law still depends in place. As we watch this unfold, one thing is certain: the outcome will echo beyond the courtrooms of the United States and Guyana. It will shape how countries like Guyana, rich in resources but still defining their post-colonial independence, assert their right to govern themselves, even when the gavel of a global power calls. This is Caribbean Tea. That's it for now. Until next time, stay informed, stay engaged.